Yes, we have major breaking news in that I published another major article, this time explaining in great detail how the licensing officials in America in the deep blue jurisdictions are delaying the process of issuing concealed carry permits and how this violates the Second Amendment in great detail. I break this down and compare it to other fundamental rights and how they are treated by licensing officials. You're not going to want to miss this discussion of my new article in the Harvard Journal of Law and Public Policy. We'll talk about it when we come right back. Hey folks, I'm Mark Smith, host of the Poor Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. And that segues into the next big thing. As you know, starting now, there is an opportunity to vote for me for the 2026 Gundies Award for the top voice of the Second Amendment, top voice of the 2A. If you're so inclined, please vote for Mark Smith, 4 Box of Diner. You can do it every day if you wish at thegundys.com for the category of top voices of the 2A. That's right. Stiff competition this year. It always is. It's always a privilege and an honor that you all nominated me for this. And, let's see how it goes. The Gundies will be announced in January, but I need your votes now between December 1st and December 15th. Thegundys.com. All right, folks. So I think this is a big deal. I think this is going to get a lot of attention, certainly among academics and scholars and practicing attorneys. I've just published an article entitled, Licenses Delayed, Rights Denied. How Contemporary Firearm Carry Licensing Regimes Continue to Violate the Second Amendment. This has just been published in the Harvard Journal of Law and Public Policy per curiam. I'll put a link to it down below. And this is a big deal, folks, because no one has ever done this as far as I can tell. A detailed analysis post-Bruen of how licensing agencies like the NYPD, the Los Angeles Sheriff's Department, and all these other government officials, with a focus on, of course, the deep blue jurisdictions that hate guns, and how they've gone from pre-Bruen, denying individuals with illegal discretionary licensing regimes, which pre-Bruen asked, why do you need a gun? Do you have a good reason for having a gun? And if we, the government licensing official, do not think you have a good enough reason for having a gun, i.e. you're not uniquely situated or uniquely threatened in some way, then we decide you don't have a good enough reason to carry a gun in public. Well, that may issue discretionary licensing regime setups were voided or declared unconstitutional under the Second Amendment thanks to the U.S. Supreme Court's decision in 2022 in Bruen. Post-Bruen, unfortunately, we're seeing these same 6 outlier jurisdictions. You know the usual suspects. California, Maryland, Hawaii, New Jersey, New York, and so on, have shifted from exercising unlawful illegal discretion on their part of the licensing regimes to determine whether or not you have a reason to have a gun that's good enough in their eyes to carry, to now asking the simple question of, do we, the licensing officials, think you personally are trustworthy enough to carry a gun in public? They've shifted the unlawful discretion from whether you have a good enough reason to carry the gun to now, are you a good enough person to carry a gun? This despite the fact that the U.S. Supreme Court in the Chief Justice John Roberts' opinion in Rahimi specifically said that whether or not you are a responsible person is no way, no how, a basis to determine whether or not you have a right to carry guns in public with a concealed carry permit, for example. That's right. The touchstone or the key guideline is whether or not you are violently or physically a dangerous threat to yourself or to others. That's basically how it goes. So in my article, I identify the problem, which is how the discretion that is ruled to be unlawful, because remember, the U.S. Supreme Court says that when you're dealing with a fundamental right, and that the Second Amendment right to keep and bear arms is a fundamental right, and the right to carry guns in public is a fundamental right under the Constitution, you cannot have legally discretion on the part of government officials to determine whether or not, in their opinion, you can carry guns in public. That's right. And yet that is exactly what's going on here. They're trying to figure out whether or not you, the person, are a sufficiently good person of good moral character to carry a gun in public. So I explain in great detail how this game is played in a very nerdy, detailed breakdown way with extremely detailed citations and authority. Again, you can check out the article. I'll put a link to it down below. I call this process, what I'm about to describe, a form of administrative nullification. Administrative nullification. And again, these outlier jurisdictions are the ones we know about. There are about 6 of them. Maryland, New York, New Jersey, California, Hawaii, and so on. And what they've done, in my view, is a form of administrative nullification. What they do is they use what appears on its face to be a neutral bureaucratic tool designed to vet people to make sure they're not a violent danger to themselves or to others, which is really a quick process. It really should be nothing more than a NICS check at most, in my view. But we'll get to that in a moment. And instead, what these states are doing is they're learning from one another. The bad states are learning from each other about the best way to set up facially neutral systems that appear neutral on their face, but in reality give tremendous discretion to licensing officials to determine that you're just simply not good enough to carry a gun in public, and therefore they're going to deny you the ability to get a concealed carry permit in that state. Or they're going to drag their feet for so long and or make it so expensive that you're simply going to not apply or give up the process midway because it's just not going to be worth the headache in your view, in many people's views. Now, I talk about this in great detail. I lay out the details of the abuses in processing times, the amount it takes between the time you apply and the time you get your license or at least a decision. I talk about the onerous and expensive training requirements. We don't have literacy tests in the United States anymore to have the right to vote. Heck, how many people are voting right now that are A, can't speak English, and B, may not even be Americans? Doesn't seem to be a problem in these same blue states. There's also all these crazy documentation standards that I go through in great detail. All the references you need from roommates and ex-wives and ex-spouses and all this stuff and how this is nonsense. Then I talk about how some of these jurisdictions engage in what I call staffing bottlenecks, where they make it hard for people to get fingerprinted or to show up or have an interview, whatever it is, aside that's even constitutional, which it probably isn't. The point is they drag their feet by saying, well, we just don't have enough police officers. In fact, I literally quote police departments and sheriff's offices literally quoting in their concealed carry guidelines books for the public, explain in detail that things may take a long time because we police officers are super busy with other things. I have a solution for how to solve that problem when I get to at the end of this article, and I'll get to that in one moment here. So I go through these bureaucratic choke points in great detail, and I give a series of real-world examples with actual litigation documents out of Boston, Los Angeles. One plaintiff actually waited over 153 days in Boston without getting any contact after applying. Los Angeles, of course, was sued by the Department of Justice. I have a feeling the Department of Justice will find this work of mine quite interesting. We'll see. New York City, of course, there's been lawsuits over how long it takes to even get fingerprinted. Again, set aside the question of whether or not fingerprinting is allowed. Certainly to the extent it is, and maybe it is, maybe it isn't. The point is it takes a long time to even get fingerprinted. It takes up, in some examples, according to complaints that I laid out in this article, upwards of 2 years. Crazy, crazy, crazy. I talk about the training requirements and how expensive it is, the amount of time it takes for live fire training. Again, we don't test people to see if they're good speakers. We don't test people to see if they're capable of reading and writing before they have the right to vote, before they have the right to exercise free speech, and so on and so on. I then get into a great series of examples, and you're going to find these insane, all the different examples that I've identified where people were denied permits for being, like, say, in a scene of a crime, never accused of anything, never suggest they did anything wrong, and yet somehow, because they were a witness to a crime of some sort, they were denied permits. I have a crazy case out of Hawaii where a guy is literally a hunter for wild boar and was denied the ability to renew his carry permit because he was supposedly under investigation for a crime, which was clearly not a crime and never understood to be a crime, and yet they denied him on the grounds that we're looking into it. That's how absurd this stuff has gotten. And I lay all this out in this article. Beyond that, I then discuss, and this is key, I make a critical comparison. I went through all these laws all across America, compared to this, and this is what I did. I compared the processing time for another fundamental individual right in these same blue state jurisdictions. I compared the amount of time it takes to get a concealed carry permit between the time you apply and the time you get a decision in these blue jurisdictions with the concealed carry permit, and then I compared it with the amount of time it takes for these exact same jurisdictions to determine whether or not you can register to vote. And then I also compared it to people who vote provisionally with problematic ballots that haven't been verified, let's say, and the amount of time it takes for them to verify whether or not you're allowed to vote. And then I demonstrate that it's literally 7 times longer, at least, and I was being very conservative with my numbers here, by the way, at least 7 times longer in these blue state jurisdictions to get your permit to carry a gun, which is, of course, a fundamental right under the Second Amendment, than it takes to get registered to vote. 7 times longer these anti-gun, in my opinion, anti-American blue jurisdictions take to issue a concealed carry permit when you compare it to how long it takes for them to register someone to vote in those same jurisdictions. And this, in my opinion, leads to the conclusion that it shows that when the governments of these blue state jurisdictions want to move with speed because they care about it, like they care about the right to vote, they can move with speed. When they don't care about a right, like the right to keep and bear arms, they drag their feet. And I think this is an apt comparison between the right to vote and the right to bear arms because A, they're both fundamental rights recognized by the U.S. Supreme Court. They both deal with government-issued authorizations to exercise the right, right? You have to register to vote. Here, you have to apply for and get a license to carry concealed permits. At least we're talking about these jurisdictions, right? We obviously recognize that there are 29 states right now that have full-blown permitless carry. You can carry a gun in public, concealed carry in 29 states without a permit. And there hopefully will be a 30th state soon in North Carolina. So what I'm really focused on are these anti-gun blue states to say, then they say, well, it takes us so long, we don't have the resources to process concealed carry permits. But then if you look at the amount of time it takes for them to process voting registration forms and the like, you can see that when they want to move with speed, they are more than able to do so. And I break this down in extreme detail, showing that the median time to get a concealed carry permit, when you look at places like California, Hawaii, Maryland, New Jersey, New York, and Washington, D.C., is 105 days. That's the median. 105 days to get a concealed carry permit in those jurisdictions, the blue jurisdictions of California, Hawaii, Maryland, New Jersey, New York, and D.C. To register to vote in those exact same jurisdictions, it's only 15 days. 105 days for the right to carry, 15 days for the right to register to vote. Totally different times, totally different processing times. There is no justification for it. So what I explained in this article is that to align incentives properly, the solution is quite simple. In those anti-gun blue jurisdictions, when you apply for a permit, as soon as you apply for that permit and your paperwork is complete and you apply, you should be issued a temporary concealed carry license on the spot. And you can start to carry. And the reason why I explain this is a great idea and should be pushed is this. Because it aligns the incentives to move fast with the incentives of the right. And what I mean by that is this. That if it is truly the case that these blue state jurisdictions, if we take them at their supposed word, which I think is all BS, but let's set the issue aside. If we take them at their word and they say, we want to make sure that the people that are carrying guns are appropriate, they're not prohibited people under, let's say, 18 U.S.C. 922G, the federal prohibited person statute. Let's say they want to check all that out. They want to run a background check. They want to run a NICS check on you, whatever it is. If you allow them or allow people to immediately start to conceal carry in that jurisdiction as soon as they apply for a permit, you now have incentivized those blue state anti-gun jurisdictions to move the speed to make sure that the person that just issued a concealed carry permit is not a prohibited person. Because the way it is now is every day they drag their feet and go to Dunkin' Donuts and get another coffee instead of processing your application. They consider that a win because they're denying Americans the ability to carry a gun on that day, which may be the day they need a gun in public to save their lives. But if you do it my way, which I talk about in this article in the Harvard Journal of Law and Public Policy in detail, you've now aligned the incentive to say, fine, they now are carrying, the individual citizen is now concealed carrying in Los Angeles today. If you're worried about him, process your background check immediately. And if there's a problem, then pick up the phone and reach out to him and tell him his license is no good because he's a prohibited person or whatever it is. But now these jurisdictions will be incentivized to move fast because they know that the people are now carrying guns in public, subject only to them doing the background check after the process has begun, after they've started to carry already in public. And if you think about it, anyone who's going to go out and commit a terrible crime with a gun is not going to go through the process of applying for a permit in the first place. As Cesare Beccaria taught us back even before the Founding Fathers wrote the Second Amendment, an Italian Enlightenment philosopher that I brought, I think, back to life in some law review scholarship I did about him. He points out that obviously the criminals are never going to comply with gun laws because if they're going to go out and commit murder and rape and robbery, they don't give a crap about guns or gun laws. That makes sense. It's common sense. We get this. But it's not a 21st century NRA slogan that I just said. That is actually from the 18th century criminologist Cesare Beccaria, that the Founding Fathers, both John Adams and Thomas Jefferson, actually wrote about back in 1791 when they wrote the Second Amendment. All right, well, I don't want to belabor the details of this article because, of course, you can read it. I put a link to it in the description below. Let me know if you agree or disagree. But at the end of the day, I view the bureaucratic resistance to Bruen as representing far more than attempts at some sort of administrative efficiency by the bureaucracy. I think this is really a coordinated effort, a coordinated strategy of constitutional evasion, the sort of mass resistance to Bruen and the Second Amendment that we saw analogously to the Civil Rights Movement in the 50s and the 60s in some southern states. And of course, to conclude, we know that a constitutional right that is delayed is a constitutional right that has been denied. All right, there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me over there on X at @4boxofdiner. And don't forget to follow me here on YouTube and Rumble. Subscribe to both. And of course, if you're going to vote for the Gundies Awards at thegundies.com, definitely check out and vote for Mark Smith, 4boxofdiner, in the top voice of the 2A. I would appreciate your support over the next couple weeks. You can vote once a day if you're so willing over there at the Gundies. Okay, we'll talk to you again real soon here. You know where, at the 4 Boxes Diner.
Orders up. Table 2A.